Welcome back to the deep dive. Today, we are opening a file that feels like it should be simple, a car crash, a slip and fall, but is actually, well, a mathematical minefield.
It really is.
We're looking at the calculus of blame. Specifically, we're asking, what happens when a plaintiff, the person suing for money, is actually partially responsible for their own injury?
It's a fascinating area of law because it represents this massive shift in legal philosophy.
Sure.
We're moving from a binary world where you're either, innocent or guilty
Right.
to a world of percentages, fractions, and sliding scales. It
Yeah.
effectively turns the courtroom into a calculator.
Exactly. We are unpacking the shift from the total bar of contributory negligence to the sliding scale of comparative negligence.
A huge change.
And then we're going to get into the really messy stuff, how damages are split up when there are multiple defendants involved. Our mission today is to rigorously analyze how damages are mathematically apportioned, specifically examining the harsh realities of joint and several liability.
Right. And to do that, we need to follow a specific analytical path. First, we have to understand the three systems of fault: contributory, pure comparative, and modified comparative.
Okay.
Second, we'll look at the visceral application of joint and several liability, what people often call the deep pocket problem.
I've heard that term.
And finally, we'll break down the mechanics of settlements, contribution, and indemnification. The goal is to build a diagnostic framework for determining exactly who pays what dollar amount in these complex multi-party torts.
Okay, let's unpack this. Let's start with the history. Before all these percentages came into play, how did the common law originally treat a plaintiff who contributed even just a tiny bit to their own harm?
The general rule is strict. It was called contributory negligence. It essentially had two elements. First, the plaintiff failed to exercise reasonable care for their own safety. Second, this failure was a contributing cause of the injury. If you met those two elements,
Then what?
the result was a complete bar to recovery.
A complete bar. So, to be clear, even if the defendant was driving drunk, speeding, and texting, let's say, 99% responsible,
Right.
and I just forgot to signal a turn, making me 1% responsible, I get nothing.
Historically, yes. Zero. The theory was that a plaintiff shouldn't receive judicial redress without clean hands.
So if you could have avoided the injury at all,
The court wouldn't help you, regardless of how egregious the defendant was.
that seems incredibly harsh by modern standards. So let's fast forward to the modern approach. I want to test this with a scenario from our notes. Let's call it the Rolls-Royce versus bicycle scenario.
A classic hypothetical. It really tests the limits of the doctrine.
All right, here's the setup. We have driver A in a Rolls-Royce. We have cyclist B. Now, driver A hits the bicycle, but the bicycle was parked a little negligently. So let's analyze this using the modern rule. First, what are the legally dispositive facts?
Okay, so in this scenario, the key facts are that A, the plaintiff driving the Rolls-Royce is found to be 90% negligent,
90%.
and B, the defendant cyclist, is only 10% negligent, but the damages to the car are significant, $10,000.
Okay. And what is the core legal issue here, considering A is primarily at fault?
The issue is, can a plaintiff who is significantly more negligent than the defendant still recover damages in a pure comparative system?
Right. So what is the rule of pure comparative negligence that applies? State the rule and maybe break it down for us.
The rule of pure comparative negligence states that a plaintiff's recovery is reduced by their percentage of fault, but, and this is the critical part, it is never barred, regardless of how high that percentage is.
So what are the elements to calculate that?
It's a three-step calculation. 1, calculate total damages. 2, determine the plaintiff's fault percentage. And 3, perform the mathematical reduction.
Okay. Now for the court's elemental analysis, let's walk through it. How do we apply those second and third elements to our 90% fault fact pattern?
Well, applying the subrule for pure comparative systems, the kind California adopted, even 90% fault still allows for recovery.
So for the application?
We take the $10,000 in total damages. We then calculate the reduction element, which is 90% of that $10,000, so $9,000. We subtract that from the total.
And after that analysis, what's the final conclusion?
The conclusion is that plaintiff A recovers $1,000. Under the old contributory system, they get zero. But here, the defendant pays for the 10% of the damage they caused.
Okay, here's where it gets really interesting for me. In that scenario, the person who was 90% responsible for the crash is getting a check from the victim who was only 10% responsible.
It feels counterintuitive.
Right. Many jurisdictions, and honestly, probably many listeners, would reject that. So what's the alternative rule?
The alternative is modified comparative negligence. This introduces what's known as the 50% bar.
And there are two ways that can work.
Yes, there are two main approaches. First is the greater than 50% approach. Here, you are barred only if your fault is greater than 50%. So if you're exactly 50% at
It
fault,
can still recover.
you can. The second is the 50% or greater approach, where if you are 50% at fault, you get nothing. It's a hard cliff.
Let's see this in action. I want to look at the case of Sutton v. Piasecki Trucking. Let's analyze this using our structure. First, the legally dispositive facts.
The facts in Sutton were that the plaintiff ignored a stop sign and was hit by a truck. The jury looked at all the evidence and found the plaintiff to be 99% at fault.
99%. And the plaintiff still sought damages. So what was the core legal issue?
The issue was simply, does 99% fault bar recovery completely?
And the answer depends entirely on the jurisdiction. Let's do an elemental analysis comparing the application of the rule in Sutton, which was a New York case, versus a modified jurisdiction like Tennessee.
Right. So applying the rule in New York uses pure comparative negligence.
Same as our Rolls-Royce hypo.
Exactly. So applying the mathematical reduction element, 99% fault resulted in a 1% recovery. The claim was not barred.
But in Tennessee,
Well, if we apply the hypothetical Tennessee rule, they use a 49% rule or 50% bar, once the plaintiff hit that 50% element, the claim is extinguished.
so the conclusion in a modified system.
In a modified system, once you cross that fault threshold, the plaintiff receives nothing. It essentially reverts to the old contributory negligence total bar at that specific point.
Okay, so that handles the plaintiff versus one defendant, but life is rarely that simple. Often there are multiple people to blame. This brings us to a concept that drives defendants crazy: joint and several liability.
It's a very controversial doctrine.
To illustrate this, I want to bring up a case that really gets the blood boiling for some people. Garris v. Phoenix.
This is the textbook deep pocket case. It really highlights the visceral impact of the doctrine.
So let's set the scene. A drunk driver kills a woman while fleeing the police. The drunk driver dies in the crash and has no money. He's insolvent. Now let's look at the breakdown of fault. The jury found the drunk driver was 95% at fault. The tavern that served him the alcohol, 3% at fault. And the city, for the police chase, was found 2% at fault.
So you have the primary bad actor at 95% and two sort of peripheral actors at a combined 5%.
Exactly. But here's the application question. Under joint and several liability, what happens?
Under joint and several liability, the city and the tavern, despite being only 5% responsible combined, must pay 100% of the damages.
100%, even though they're only 5% negligent.
Yes. This illustrates the deep pocket theory. The main tortfeasor, the drunk driver, is insolvent. The law has to make a choice. Does the innocent plaintiff lose out, or do the solvent defendants pay more than their fair share?
And joint and several liability says
The defendants pay. This is exactly why modern tort reform, like the legislation Arizona passed after this very case, attacks this rule.
that is heavy. Let's look at another example of this, specifically about how we allocate liability when one party is broke. I want to talk about Walt Disney World Covey Wood.
Ah, yes. This is a definitive case for understanding how insolvency shifts the burden.
Let's analyze it. First, what are the legally dispositive facts?
The facts are, the plaintiff, Mrs. Wood, was injured on a ride, a bumper car attraction. The jury apportioned fault as follows. The plaintiff was 14% at fault. Her fiancé, who she didn't sue and who was insolvent, was 85% at fault for ramming her.
Okay.
And Disney was found to be just 1% at fault.
So Disney is 1% liable, the fiancé is 85% but has no money. And what was the core legal issue?
The issue is, can a defendant with only 1% negligence be forced to pay 86% of the damages? Their 1% plus the insolvent fiancé's 85%.
Wow. And what rule regarding joint and several liability did the court apply? Please break it down for us.
The rule is that each tortfeasor is individually liable for the entirety of the plaintiff's recoverable damages if the injury is indivisible. The elements are generally 1, multiple tortfeasors, 2, an indivisible injury, and 3, at least one solvent defendant.
Let's break down the elemental analysis on the insolvency risk. How did the court apply the element of risk apportionment to these facts?
Well, the court looked at who should bear the risk of a co-defendant being broke. The element here is the apportionment of risk.
And its application?
The application was that the law favors the innocent, or in this case, the less negligent plaintiff getting paid over the fairness to the wealthy defendant. The court decided that the risk of the co-defendant's insolvency falls on the solvent defendant, Disney, not on the plaintiff.
So the final conclusion.
The court affirmed that Disney had to pay the lion's share, the 86%, despite having only 1% of the fault.
That is wild. 1% fault paying 86% of the bill. Now, because of scenarios like this, defendants often try to get out early, they settle.
They do. It changes the landscape for everyone left in the courtroom.
Let's run a hypothetical. Plaintiff A sues defendant B and defendant C. The total damages are $10,000. B is 30% at fault and C is 70% at fault. Now, let's say B settles early for $1,000.
A very low settlement compared to their likely liability.
Exactly. So the issue is, how does B's settlement affect what C has to pay?
There are two competing rules here, and they yield very different results.
Break down the first approach for me.
The first is the pro tanto, or dollar amount approach. Here, you simply deduct the amount paid by the settler from the total judgment.
So the math would be?
$10,000 total damages minus the $1,000 settlement. That equals $9,000 remaining.
So C, who was 70% at fault, ends up paying $9,000.
Exactly. Under pro tanto, C pays $9,000. C is effectively penalized because B managed to settle for a low number.
Okay, that seems rough for C. What is the second approach?
The second is the pro rata, or percentage fault approach. Here, you deduct the percentage of fault attributed to the settler, regardless of what they actually paid.
So the math there
is $10,000 minus B's 30% share, which would be $3,000. That leaves $7,000.
So C only pays $7,000.
Yes. C pays only their exact share. But notice what happens to the plaintiff. They got $1,000 from the settlement and $7,000 from the judgment. Total, $8,000. They're short $2,000.
So in the second approach, the plaintiff is the one penalized for settling too low.
Precisely. It shifts the risk of a bad settlement negotiation onto the plaintiff.
Now, speaking of settlements, I saw a term in the notes, Mary Carter agreements. What on earth is that?
A Mary Carter agreement is a fascinating and somewhat controversial tactic. It's a secret agreement where a defendant stays in the trial but settles with the plaintiff contingent on the outcome.
Wait, so how does that work?
Basically, the defendant guarantees the plaintiff a certain amount, but that amount goes down if the plaintiff wins big against the other defendants.
So it incentivizes the settling defendant to turn on the other defendant.
Exactly. It creates a secret alliance in the courtroom. The settled defendant suddenly starts helping the plaintiff prove that the other guys are totally at fault.
Sneaky. All right, last doctrinal piece. If a defendant like Disney ends up paying way more than their fair share, can they get that money back?
That brings us to contribution and indemnification. These are the two remedies for a defendant who has overpaid.
What is the difference?
Contribution is about seeking partial reimbursement. If Disney pays 86%, they can sue the fiancé for the 85% share that was his fault.
But if the fiancé is broke,
then contribution doesn't help much in practice, but legally, that's the remedy. It's for splitting the bill based on percentage of fault. It's usually barred for intentional torts, though.
okay. And indemnification.
Indemnification is a total shifting of liability. It's not about sharing. It's about passing the buck entirely.
What are the elements for that? When does that happen?
It typically occurs when one party is actively negligent and the other is only passively or vicariously liable. Think of an employer being sued for an employee's crash.
Or a store for a defective product.
Exactly. A retailer sued for a manufacturer's defect. The passive party, the retailer, can recover 100% of what they paid from the active party, the manufacturer.
Got it. So contribution is splitting the check. Indemnification is making the other guy pay the whole tab.
Precisely.
So what does this all mean? We've covered a lot of math and doctrine. If you're staring down an exam question or a complex case file, how should you attack it?
Let's synthesize this into a step-by-step diagnostic checklist. If you are analyzing a fact pattern, do this in order.
Okay, step one.
1. Check the defense. Is the jurisdiction using old-school contributory negligence, a total bar, or comparative negligence?
Step 2.
If it is comparative, check the type. Is it pure, where the plaintiff always recovers something, or is it modified? If it's modified, check if the plaintiff is at or over 50% fault. If they are, they might be barred.
3.
Check assumption of risk. Has it been merged into comparative fault? Usually the answer is yes.
Okay.
4, count the tortfeasors.
Yeah.
Are there multiple defendants? If so, you move to 5.
Which is?
Apply joint and several liability. This is the big one. Are the damages economic or non-economic? And always check for insolvency. Look for that deep pocket issue.
6.
Calculate settlement offsets. Does the jurisdiction deduct the dollar amount, which is good for the plaintiff, or the percentage of fault, which puts the risk on the plaintiff?
And finally, 7.
Post-judgment remedies. Can the paying defendant seek contribution for a partial payback or indemnification for a total payback from the others?
That is a powerful framework.
It covers the bases. If you follow that logic, the math clarifies itself.
Here's where I want to leave everyone today. We talked about fairness. We talked about Disney paying for someone else's negligence. It raises a provocative thought about the moral hazard of all this. If we shift to a system where we are constantly slicing up the blame pie and where deep pockets pay for insolvent bad actors, does this actually incentivize safety? Or does it simply allow bad actors to hide behind the insolvency of others, knowing someone else will foot the bill? It's a question of whether the law should prioritize compensating the victim at all costs or strictly punishing the specific wrongdoer. Something to mull over.
It certainly complicates the definition of justice.
That's it for this deep dive. Thanks for listening.